CR008409A, State of Texas versus Luz Rodriguez Pizano. Are you all ready? Writ hearing, bond reduction, are you all ready?
Yes, Your Honor.
All right, so I'm gonna tell you, I consider these things one or the other. It's either a bond reduction, a request for a bond reduction, or it's a writ. So, what are we doing, a bond reduction?
A writ, Your Honor, seeking a reduction in the bail amount.
Okay, well, all right, then it's a bond reduction hearing. Are y'all ready?
Yes, ma'am.
Okay. Ms. Rodriguez Pizano, can you hear me?
Yes, ma'am.
Are you the same Luz Rodriguez Pizano from 2024 CR 008409A was charged in Guerra County, Texas with the offense of aggravated robbery, actually also in 2024 CR 2904. Is that you?
Yes, ma'am.
All right, now your attorney has filed a motion seeking bond reduction on your case. Mr. Esparza, are you gonna take lead on this one?
Yes, Your Honor.
Okay, go ahead.
At this time, as a housekeeping matter, I have an affidavit, if I can approach the bench.
Yes.
Pre-marked defense exhibit 1, handing it to the judge.
Objection? Has the state had a chance to review it?
I provided a copy, Your Honor.
That is correct, no objection.
All right, it's admitted.
Your Honor, that is the only evidence that we have to support it. The court wants to take some time to review the affidavit.
Am I right that there are 2 aggravated robberies pending?
There are 2 aggravated robberies pending. When I filed our filing, we were only appointed on one of them. Michael Sawyer was the attorney for the other one. But as of yesterday, I believe, we are now appointed to the second one. So that affidavit reflects the cumulative bond amount for Ms. Pizano.
That's what my question was. All right. So you're talking about a cumulative amount on both cases of $75,000?
Yes, Your Honor.
So seeking reduction from a total of $850,000 to a total of $75,000.
Yes, Your Honor. And I have a case I can talk about as well as argument to make. Do you want to hear that now, or do you want to?
I want to. Do you have anything else? Or are you going to rest on evidence?
I'll rest on evidence.
Okay. State.
Judge, at this time, Judge, at this state, the state just has to offer States Exhibit 1, the prosecution guide supplements to to one of the robbery charges. I actually neglected to bring the other one out. I was trying to pull that up now, but I can as well. There's similar related offenses from the same day.
Do they rise out of the same incident?
No, they occur on the same day, but they're related, but they're not the same incident. So I'm trying to get a copy of that for the court as well. So if you give me a few minutes, I can get that. I apologize for not having it ready. I thought
That's
I was
fine.
going to be in here. But if I can approach the offer States 1, which is just the prosecution guide.
No objection.
All right. Good. Go ahead and let me start with that one, and then do the best you can. Just hold the other, and I'll give you. Thank you.
Judge, I also have, for court, the prosecution got from the other case that, obviously defense was appointed to yesterday. I'm providing them a copy now. I was reviewing through the e-discovery. It doesn't appear that it's been uploaded. Obviously that's only been rectified. But I've given them a copy now and I have a copy for the court as well.
Okay, so you wanna mark that as what, State's Exhibit 2?
Yes, Judge, if there's no objection, state would authorize
Objections?
states to.
No objection.
And did you say you gave me a criminal history? I didn't have it.
I did not provide a criminal history, Judge. I can certainly provide a copy of the court of that.
I think by code I'm required to know.
Sure.
Yeah, thank you.
Do you want a copy of the NCIC or just want to read into the record?
It doesn't matter to me, but by code I'm required to know the defendant's criminal history, but let me look at this first and then we'll go there, all right? And I've reviewed both State's Exhibit 1 and State's Exhibit 2 as well as Defendant's Exhibit 1. Are there further exhibits at this point, or you just wanna
Yes,
tell
Judge.
me what?
So I think if it's okay with the court, excuse me, my intention would be to offer State's Exhibit 3, which is a copy of the NCIC on Ms. Rodriguez-Pisano. However, I would withdraw at the end of the hearing just because of the rules.
You
on-
would do what?
I would like
Oh,
to
yeah.
withdraw at the end of the hearing just because of the rules on
Certainly.
secure data.
Any objection?
No objection, Judge.
It's admitted.
Your Honor, I guess it should be clear, no objection under the provider. The prosecutor renders the record that he will withdraw the exhibit.
Are you not objecting to withdrawing either?
No.
And the court has reviewed State's Exhibit 3. Anything else?
Nothing further from the state, Judge. State rests.
Just argument.
Go ahead.
Your Honor, I know the court has reviewed this Exhibit 1 as well as States 1 through 3. I'd like to begin with a case to cite for the court, Chavez v. State, 671 Southwest 3rd, 775, and I will provide this case to the court at the conclusion of my argument. Where it starts, the facts of Chavez are arguably worse than what we have here in the present case. Chavez was a murder case where he was the primary actor, in fact he was the shooter. And when it comes time for a bail reduction hearing, the facts of Chavez
Let me ask you this, is Court of Criminal Appeals?
is Texas Court of Appeals out of Fort Worth.
Go ahead.
Chavez is accused of a violent offense. He has criminal history, as an adult. He had failed to appear before on at least 2 prior occasions. But as far as some of the other factors involved that the court normally considered for bail reduction, in Chavez, bail went from $1 million down to $275,000, despite those facts. And the reason they did that, the law that the court I know is familiar with, the Chavez court said in our society, liberty is the norm and detention prior to trial is the limited exception. And they said that we know this because of the prohibition against excessive bail as punishment as contained in the 8th Amendment of the United States Constitution, as well as the Texas Constitution, Section 1, Articles 11 and 13. And they said that bail is excessive if an amount greater than is reasonably necessary to satisfy the government's legitimate interest. And they said the only legitimate interest and bail's primary purpose is that you ensure the reasonable appearance of the defendant at trial. And you look at the factors that are contained in 1714. And when you look at these individualized factors, you've seen, Your Honor, from your review of States 1 and 2, Ms. Lozano has limited involvement. She's a secondary figure. If you're familiar with the facts from your review of prosecution guide and States Exhibit 1,
I'm familiar with the fact that she appears to have possibly been the one who set up the meeting in States Exhibit 1, and that in States Exhibit, and it was her car that they used. In States Exhibit 2, it appears she's the driver.
correct.
And she's also the same one who was in contact with the victim a month prior to the aggravated robbery.
Correct, but she's not the individual with the weapon, and she doesn't ever exit the vehicle. In fact, there's statements and evidence in the prosecution guide, or States Exhibit 1, I believe, where there's a question of whether or not she's even awake during part of that stop when the individuals get out of the car.
But
to go commit the robbery.
am I misreading it, or
No,
was she not in the apartment at the time that the murder?
Not at all, not at all. She is not in the apartment at all. She never exits the vehicle. She is 23 years old. She has no adult criminal record. I realize that there is some juvenile history before the court.
So let me ask you about the juvenile history, because I think it just is one third-degree felony that's repeated over and over again in the NCIC, TCIC. I don't think it's separate
Correct,
offenses.
that's how it appears to me.
And a theft.
Yes.
Yeah, and those are juvenile cases.
Those are juvenile. She has no adult criminal history. She's been incarcerated at the county jail here in Guerra County for over a year, awaiting trial. I think that's a significant factor. Because continued detention under these circumstances now reaches the point where it's punitive, rather than for any reasonable assurance that she would appear at trial. From Defense Exhibit 1, she does have community ties to San Antonio. She's lived here for the past 10 years. Prior to being incarcerated, she did have a job here at Improper for the court. She worked at a restaurant. Her mother is supportive and willing to supervise her release and even give her a place to live if she can just make bail. She's not a flight risk and she's not a danger to the community. There's no evidence before the court that she poses any particularized, identifiable danger to anyone or any Guerra County citizen. A bond set at this amount, Your Honor, our position is tantamount to no bond at all, because it's an amount that her family cannot reach by any means. We would ask for this reduction to reflect her limited role in the offense, allow her to get out so she can assist us better in her own defense, while still constituting a substantial financial obligation for her family. And Your Honor knows you can attach, if you were to give this bond reduction, you can attach conditions onto that bond. GPS monitoring, home confinement or curfew, no contact with the co-defendants, regular check-ins with pretrial services. You can even restrict your travel and keep her here contained in Guerra County. We would ask that this reduction occur because we believe it's reasonable in line with the constitutional case law considerations before the court regarding excessive bail. It's sufficient to ensure her appearance, which is the primary purpose for bail, and it's fair in light of the defendant's secondary role, history, and her personal circumstances. Plus, Your Honor, she was cooperative when she met with police. And in point of fact, even when this was originally being looked at as a capital murder during the investigation, not only was she cooperative in talking to police, there was no attempt to flee the jurisdiction, which she knows she's already being talked to and looked at. She was here and she remained here in Guerra County at the time she was arrested. So we just ask the court respectfully for a reduction.
I think my confusion here is that she talks about the apartment, but your contention is she's talking about being at the apartment complex.
She never
Because
goes.
she says the apartment, but
She does not go in the apartment.
I know she says that,
Prosecutors.
and then she refers to the apartment, and I think that's my confusion.
And
Anyway,
there's no evidence in
Yeah.
the case that I'm aware of that she ever exited the vehicle or went into the apartment.
And Judge, just to kind of follow up on that, that's my understanding as well.
Okay.
Is that she stayed in the vehicle. One of the two co-defendants actually gave a subsequent interview where he puts himself and the third co-defendant, Jordan Maison, inside the room. But he does not put their client, Ms. Pisano Rodriguez, or Rodriguez Pisano, in the room at that time. So as far as I'm aware, what we have in the case at this time, that doesn't give us other information. I think essentially she is, as you said, the person that kind of sets it up, kind of gets them in position to where that thing can occur, but she doesn't actually physically enter, she doesn't physically have a gun in her hand when these incidents occur.
I think my confusion, like I said, comes from her referring to the apartment and not the apartment complex parking lot. You see what I'm saying?
Yes, I understand.
Throughout her statement, she refers to the apartment. So I think that's where my confusion comes in, and I needed clarification. So, yeah.
May I approach you to present
Yes,
by
absolutely.
Chavez estate to the court?
Ultimately, I'll read it, but what is the problem? What was the conflict in Chavez? What are we talking about?
Chavez was excessive bail, for that murder case, about $1 million.
And they said that the million down to, because you said
It came down to $275,000.
and they said it was still too excessive?
No, the $1 million was too excessive, even for the murder case and for everything else in Chavez.
All right.
And Your Honor, I will say, I didn't take a chance to print, I thought I printed both. The 275 is mentioned in the second ex parte on Chavez, which is a follow-up to that case. It's mentioned in the first paragraph. I do have that on my phone, I apologize. I thought I printed both cases.
Well, I can certainly read that from here. Let me
Do you
take.
trust my proffer, Your Honor, or shall I approach it myself?
I
don't
do not
think-
object to the candor to the court, by saying I do not believe he's misleading the court.
I don't think he is either, based on my experience with this particular attorney.
Thank you.
Oh, you're welcome. You can get a copy of the record. Well, I have no doubt that you're exactly right about this case, but you want me to read the entire thing? I certainly
No, Your Honor,
have no problem
I've
doing
gone
that.
here a couple of pages if you want to look at the document.
I generally do read the entire case. Let's see if I can get to wherever hearings.
Your Honor,
Yes.
one point I forgot to mention, and speaking of candor to the court, in Chavez, his father's family was in Mexico, and the state, I think in that case, tried to say he has significant ties to Mexico. And despite that, in terms of flight risk analysis, the court was not persuaded and found no evidence that even having family or connections to a foreign country like Mexico mattered in terms of
I
bond
guess you're
reduction.
pointing that out because there is something in State's Exhibit 1 that talks about her having a Mexican driver's license.
Yes, she is not a U.S. citizen, but I bring that up to the court though to show, and that's the reason I picked Chavez, is it has no bearing or impact in this case.
Are you saying that there are other cases where it does?
No, Your Honor, I'm not saying that.
Does she have an ISOL?
She does not, Your Honor, that I'm aware of.
Yeah, it just occurred to me that it might be something we might want to miss.
Which I don't see that she's, looking through the honest system, I don't see any additional holds other than the two current charges.
We've checked with the jail as well as the court. And it's the same thing.
I'd keep checking though.
Yeah, that was kind of a point that was brought up.
has she been in the United States?
Since she was a child, Your Honor.
That's because that's part of the Chavez case talks about that basically the connection to the community and how long family had been in, I guess it's Wichita? Yeah. Okay, that's why I'm asking. It's in your case law. Okay. All right. Anything else?
Nothing from the defense, Your Honor.
State.
Yes, Judge. So, obviously, as the court can see from the prosecution guide, these cases were brought in as a capital murder affiliated with an aggravated robbery. So, obviously, for an aggravated robbery, the bond of $850,000 is probably high by the county standards, but certainly the judge and the magistrate who set those bonds will take into consideration the facts of the case. And so we do believe that a high bond is appropriate. And somewhere in the intake process, reviewing the evidence provided by the San Antonio Police Department, the intake department made the decision not to pursue charges for capital murder, but go with the first-degree aggravated robbery instead. So certainly there may be some discrepancy between what would normally be set for that offense versus what was.
Can you tell me, because the total amount I know is $850, but I don't know what the two separate amounts
The
are.
one that is formerly a capital murder, and I can probably get the identifying information, it was the one that is actually filed on.
I got it, because that's the one he filed the
Correct.
habeas on.
That one is set at $600,000, the other was set at $250,000. She was booked-
250?
250, yes, Judge. So she was booked in December of '23, I believe it was, on both cases at the same time. So she's been in custody, obviously, continuously since then. The state's position is that $75,000 is too low. I did find the case law that the defense was talking of, and I certainly agree that a lot of the points they said are relevant and important. The one that the state would certainly argue on is that her criminal history did not indicate a significant ongoing safety threat. I think in this case we see the opposite of that. I mean, she is not the gun man. I don't know that she's the idea man. But certainly she is a pivotal part in this scheme that they were running that led to one person suffering an aggravated robbery and one person, because it went wrong, because it didn't go the way it was supposed to, but certainly it went a way that would have been foreseeable if you go into an apartment to steal guns from a person while armed, that certainly somebody could get shot, somebody could die. So there are very serious offenses, and the bonds, the state believes, should reflect that. But we defer to the court's discretion as to whether the $600,000 and the $250,000 are higher than they should be.
Well, the 600,000 is higher than it should be. I'll say that outright. Here's my question. Let me find State's Exhibit 1 again. State's Exhibit 1, it's not right. Which one occurs first? The one at Deer Park or the one in the apartment?
Your Honor, I believe the one at
Deer
Deer
Park.
Park occurs first.
So, you know, she would know that they were armed. Because the facts in State's Exhibit 2 indicate to me that she's in the car, they get out, and they rob this man that she's been in contact with for a month at gunpoint, both of them. And so she would have known that they were armed. Let's put it like that. And the state's not suggesting any specific amount. I'm sorry, Mr.
And
Clark.
just the point occurred to me too, following the court's logic, the first robbery did not end in death.
Well,
or had
correct.
actual violence.
Correct, but she's aware that they have firearms and that this is what is going on. Yep. Okay. That was my question. Do you have something that you well, I guess not, because it's just this one case that they have filed. I'm gonna need an order on the second case. See what I mean? I need an order on the second case. Somehow, some way, because I only have an order on one case, So,
And Judge, obviously, they weren't on that case, and I didn't object to obviously arguing that case, notice or anything like that. I certainly don't object to them supplementing with an order, with or without saying they copies of the court.
so are you objecting to us even having a hearing on the second case?
No, Judge, that's what I'm saying. Sorry, obviously we've done that already anyways,
Okay.
essentially, and I
Focus
offered
on that.
evidence on that. But certainly they are aware of both cases. They were just physically appointed in place of Mike Sawyer, so that there was a consistent representation for the defendant in both cases. So I don't object to you ruling on that. I don't object to them arguing on that. I don't object to them supplementing with an order.
I thought you were objecting to
No,
it.
sorry, just to
Okay,
clarify
I
that.
thought you were objecting to it, and I was gonna say, well, I can't unring the bell, right? Okay, so let's see. On 2024 CR 008409A, I'm going to reduce this bond to $250,000 on this other case. On 2024 CR 2904, I'm reducing the bond to $75,000. In each case, she's gonna have GPS full house arrest. She's not to leave Bear County, obviously. No firearms possession. Urinalysis, random monthly urinalysis. No contact with this, really is the first named complainant. Let's see what his name is.
Ronald Stevens, I think, Judge?
Ronald Xavier Stevens, date of birth, January 29th, 1999. Alright, so no contact there. Obviously, where are these other two guys? Are they charged?
Yes, Judge. So Jordan Maison actually just picked up a new charge, so he's in custody right now, but he'd previously been on bond. And then Duron Pittman, his charge was actually upgraded to a capital murder. So he's in custody pending charges on capital murder. So I would ask for no contact with both, but they are both, at least at this time, in custody.
Correct, and that's what I'm asking. So no contact with Jordan Maison or Duron Pittman. And she's gonna live with her mother, is that right?
Yes, ma'am. It's actually moved out of the room.
Well, obviously, because she's gonna be on GPS, full house arrest, if she's gonna live someplace else, she's gonna need to have an order, okay?
Yes, ma'am.
All right, anything else on this particular case, other than you bringing me an order, so I have something to sign and something to set on conditions on it? Nope?
No.
Okay, all right, we'll see you when you can read that to me, hopefully within the next few hours. Yes? Okay, thank you.
Is that something I can email to you? Or would you rather physically read it?
I don't have account email,
I'll do it.
so remember, I don't really exist here anymore, only on certain special dates, so. And I don't use my personal email for any of this stuff, so. Right.
And your Honor, with your approval, I think I spoke to Brown would be if I emailed the order to the board.
You do whatever it is you need to do to get that to me. Okay. You know what, I must also put a condition on here that she's not to have any social media. I don't know how they would do that, but if we find out she's got social media where she's doing the same thing that she was doing, if pretrial finds out she's contacting people over social media to set up meetings, done, okay? purposes of confidentiality as required by law.
State has received, states three, Judge, thank you.
You're welcome. Anything else, folks? Okay, so I'm gonna just leave this when I hit the other order, just have to make some changes. Up. You good? Sure. Okay. Absolutely.
Thanks, Judge.
We're gonna take up 2025 002455 State of Texas versus Jacqueline Hodge. Come up, please.
Yes, would you please?
You all ready?
That's right.
State's ready, Your Honor.
Ma'am, are you Jacqueline K. Hodge? Are you the same person who in 2025 CR 002455 was charged in Bear County, Texas with the offense of robbery?
Yes,
All right, now, your attorney has filed a motion to modify or delete bond conditions. Go ahead, please.
Judge, I would primarily rely on the four corners of my motion, and then I do have one exhibit for the court.
No objection from the state.
Defense Exhibit 1, Judge, is a printout of the case details of this cause number from the public policy system. And I've taken the liberty to underline a couple of events that I think is important to the court. Number one is the date in which my client was booked to the Guerra County Jail, that being April the 20th of 2024. She was then released on bond 2 days later on April the 22nd, 2024. At this point, I'd like to point out the state's obligations under the Code of Criminal Procedure in that my client being discharged to bail had till the end of the second term of court to indict her. That would have put the magic date at New Year's Eve of 2024. That did not happen. I was subsequently appointed. I'm not the first attorney on this case. And it wasn't, but for me filing a motion for an examining trial, the state finally took a look at this case. And the reason
It's 4/20, let me make sure I've got this right, 4/20/2024.
is the arrest.
Not indicted until January 31st, 2024.
Correct, Your Honor.
Okay, go ahead.
Correct. And then was subsequently finally indicted. She has been on GPS full house arrest since her commitment to bond. That's also denoted in Defense Exhibit number 1, which you'll also notice that it's missing from the details is there are no violation reports that were ever submitted on my file.
So what are you asking for exactly? Just to take her off of full house arrest?
Removal of the GPS unit at this point, Judge.
Okay, state?
State has 3 exhibits that I'd like to introduce into evidence. State's 1, which is the bail amount. State's 2, which is the criminal history in Guerra County. State's 3, the police report, prosecution log. They have been shared with defense counsel.
Judge, I would say they were previously tendered to me. I have no objection.
Admit.
exhibit number 3. The section, it's a 3-page section written by the submitting detective, Francisco Gallegos. And if you look at page 2 of Detective Gallegos' synopsis, you'll find his review of the evidence and the claims of this complainant in this case. And what we have here is a complainant, it's been verified, did not tell the truth to police. He claimed there was a gun. Video evidence refutes that. He claims a threat was made. Video evidence also refutes that. All we see is 2 individuals allegedly accused of shoplifting who drove away from a mall security officer who opened fire on them with pepper balls.
I see what you're saying.
At this point, I mean, the fact that this is indicted, and not only indicted as a robbery, but indicted late, demonstrates this district attorney's office's negligence and or incompetence. And at this point, subjecting her to any further...
You win. You will not say anything else, you win, okay? So I'm removing the GPS, that's what you're requesting,
Yes,
right?
ma'am.
So she's no longer on GPS house arrest. Don't go to Macy's, I'm sure there's no contact on there, right?
If there's not, Judge, you're not going to object to that being ordered.
Any Macy's.
The victim's name is Michael Kawa.
Is there not a no contact with him now?
Did not find no contact. I did produce
Why?
the bond information.
I know, but why wouldn't someone have requested a no contact order before this with Michael Kala?
The state requested no.
I'm gonna do it. Don't go back, don't have any contact with this guy. And I'm talking about any Macy's. Anything else? Granted.
May I be excused, Judge?
Yep, sure may, thank you, here we go. Put his head on the door and walk back out.
What's up, you?
He's talking to his client's family. That's my understanding. Who's, okay, let's see, we got it. What else are we doing? This is so busy. So this is on, is, oh, I see, okay. And then, you're right, this is in Laura. Yes. I take anything that's ready. So, if you're ready to take it up, if you're not, you just have to wait. When you get finished with whatever's ready. Yeah. Yeah, I did. Okay. Let me just let you know, guys. I'm gonna get these started. Just let me know, Mr. Lott.
Yes, Judge, thank you.
As soon as you're ready. Oh, you're fine. I just, one of the ways it goes, so I think my crash behind. Right. Just don't want Judge Rodriguez to come back and charged by the grand jury in Guerra County, Texas, with the offense of unauthorized use of a motor vehicle.
Yes, sir.
Are we here on both cases?
Yes, Your Honor.
This is 5196, okay, yes, and I also have an additional case, 2022 CR 6329, who the same Alfred Losoya, who has been charged in Bear County, Texas, with the offense of aggravated robbery.
Yes, Your Honor.
All right, and your attorney, sir, has filed motions in each one of these cases, motions to amend bond conditions. All right, Mr. Lotta, go ahead, please, sir.
Yes, Judge. Judge, Mr. Losoya is asking this court to allow him to work, and we're asking to modify the conditions to tracking only as opposed to full house arrest. We do have an agreement with the government on the other cases, Judge. We're just waiting for that new court date to come in for Mr. Losoya to take responsibility for those, the motion to vote.
So let me see if I understand what you're trying to tell me. He has a motion to revoke his community supervision. Is it on one of these?
That's correct, Judge.
Is it the aggravated robbery?
It's both, Your Honor.
So these are motions to revoke, both of them.
That's correct, Judge, for what we filed for.
So he's on probation.
That's correct, Judge.
All right. Go ahead, counsel.
Thank you, Your Honor. The state has some exhibits it would like to introduce. It's already shared with the defense counsel. States 1 and States 2 are the motions to revoke. States 3 is the bond information for both cases. States 4 is the criminal history report from Bear County. States 5 is the police report on the unauthorized use, and State 6 is the police report on the and the state moves for the introduction of those.
No objections, Your Honor.
They are exhibited. One moment, please. So y'all are alleging new cases on the motions to enter adjudication of guilt, revoke community supervision. You're alleging violations of condition number 1, engaging in organized criminal activity.
Yes, Your Honor, those are alleged.
I only really see only one of those as filed and pending. But it appears that you also have a theft of property, $2,500 to $30,000 pending. Is that correct? And those are unindicted cases?
Indicted, yes, Your Honor.
about the removal of GPS. He just wants to work the last 2 weeks before entering into the adjudication on his MTRs now.
So, are you telling me that he's gonna go to prison?
My understanding that we don't know. We don't know
Okay.
what's going to happen with that judge. That's why they've been pushing it off.
State defers to the court. The state defers to the court.
This is denied.
Judge, that's all I have. Maybe.
Yes, thank you. Which one are y'all gonna be ready on first?
I think, they wanted to do Amara first.
Okay.
More than
I'm just gonna go. Let me know, 'cause I'm not done. I'll let you tell me when you're ready.
They're all just letters.
I can get everyone to scoot down as close to the wall as possible. We have a few other ones.
Sorry, I think I'll remember this.
I can get everyone to scoot down.
Why don't y'all go ahead and you're just reviewing what they intend to give me, is that what you're
Yes,
doing?
Judge.
Let me know when you're finished.
Yes, Judge.
Okay,
Thank you. You see my text I sent to you? No, I said you, Monica, I'm sorry. I'm sorry.
All purple.
Did you see the text I sent to you?
Another song? It should be. I know with the e-filing thing, you have copies of the motions ready to print them for you.
Because Monica gave them.
Okay.
So she printed them for me
Okay.
already.
Okay.
Thank you, Monica.
Thank you, Mom. In both cases?
All three cases.
No, but I mean in both,
Oh,
in
yeah.
both defendants, I should have said.
Yes.
Okay.
Oh. Well, we're just taking up, yeah.
Right,
We're
right,
just
right.
taking up Amara right now.
Yes.
Okay.
the appropriate time. I was just trying to
Okay.
expedite the process.
Okay, all right.
Oh, God, sorry. Snoop up on me.
also not marked, I'm gonna give them back to you. Yes, absolutely. All right,
Stapled in the park was one.
that's fine, I will do that. Yes, I will do that. Otherwise, we're all moving towards ready on this. You have more to do?
Stage ready, Judge.
We're ready, Judge.
Ready? Okay. Mr. Amato, can you hear me?
Yes, ma'am.
All right then. This is cause number 2025 CC 003207, 2025 CR 003208, 2025 CR 003209, all styled State of Texas versus George Amato. Sir, is that you? Are you George Amato?
Yes, ma'am.
The same person who was charged in 2025 CR 003207 with burglary of a habitation, in 2025 CR 003208 the offense of murder, and 2025 CR 003209 the offense of aggravated assault. Is that you, sir?
Yes.
Your attorney has filed motions to reduce your bond and waive GPS fees. Counsel, go ahead, please.
Thank you, Judge. I would, for the purpose of this hearing, I'd like to call Roxanne Hernandez.
Ms. Hernandez? And I think we're just putting her at counsel table, is that correct? Ms. Hernandez, if you would please raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. You can put your hand down, go ahead, please.
Thank you, Judge. Ms. Hernandez, do you know my client, Mr. George Amaro?
Yes, I do.
And how do you know George?
He's my nephew.
How old is George?
24.
I'm sorry.
25. We're 24. We're 24.
And how are you related to George? You said he's
My
your nephew?
sister is his mother,
Okay. Now, what's his mother's name?
Roseanne Johnson.
And I noticed that today we have some of George's family members in the courtroom. Is that correct?
That is correct.
Can you please tell the George who's present on George's behalf today?
His on his dad's side, it's his mother and father, so grandmother and grandfather, his aunt, his cousin, his brother, his sister, his father, my mother, and myself,
Now,
and
George,
his other aunt. I'm sorry.
okay. Now George has pending today 3 different felony charges. Are you aware of that?
Yes.
And the purpose of today's hearing is to ask the honorable court to reduce his bonds. His bonds collectively total. He has one bond of $100,000, one bond of $250,000, and one bond of $120,000. Are you aware of that?
Yes.
And let me first ask you some questions about George. Are you personally aware of George's financial situation?
Yes.
Does George have himself the kind of money available to him to raise the money that would be required to post those bonds?
No.
Does George own himself any real property?
No.
Does he have any stocks or bonds?
No.
Does he have any bank accounts?
I think he has a checking account for direct deposit and work.
Are you familiar? Is there a balance? Do you know the balance in that account?
It's at 0.
Okay. Does he own any real property?
No.
Does he own an automobile?
No.
Does he own a home?
No.
At the time this offense occurred, where was he living?
He was living off of Petrenko Road.
And was he renting an apartment, or was he living?
He was renting an apartment for himself.
And was he working at that time?
Yes, he was. He was working full time.
And where was he working?
Tyndall Corporation.
Now, if he was not able to raise the money himself to post these amounts, have you and your family members been trying to raise the money?
Yes.
Have you been able to come up with the funds necessary
No.
to raise these bonds?
No.
Okay. And you are aware that we're asking the judge in each one of these cases to reduce the bonds?
Yes.
And you and I, and you and I have met, and other family members as well, and we've discussed the various conditions the court can place on George. Is that correct?
Yes.
And those conditions include what's commonly called GPS.
Correct.
And you know that's a device one would wear equal.
Mhm.
And the purpose of that is to ensure the court and the community that someone knows where George is at all
That
times.
is correct.
Now, without telling us a specific address, is there a location in Bear County that one of the family members will allow George to live
Yes,
if he was to post bond?
yes.
And without telling us the name of the family member, is it one of the family members that's present today?
Yes.
And would that person be able to be around George while he's there at the house?
Yes.
And you are aware the court could compel George to stay at home or at that home all of the time?
Yes.
And the purpose of that would be, once again, to make sure that we know where George is.
Right.
Because one of the things the court needs to know and be comforted in is to know that the community is safe from George.
Right.
And knowing where he is one of the ways this honorable court could do that, correct?
Yes.
Okay. Also, we've, at this time, Judge, I'll offer new evidence what's previously marked as defense exhibit number 1. I've tendered to state.
Just say that's one thing.
And Judge, I think, for the purposes of the record, defense 1 has been previously tendered to the court for the court to review.
If those are the letters
Yes,
of
yes.
support, that is correct, and I have reviewed them, and they are admitted.
And Ms. Hernandez, I'm gonna show you what I've marked as defense exhibit number 1. Take a second and flip through these if you will. I think you're familiar with them, just make sure they are what I believe them to be.
Yes, they are letters of character.
And these are letters that were provided to my office from you and other family members and friends, associates, and even individuals that George has worked for and with. Is that correct?
That is correct.
Okay. In this particular instance, and I'll go through the bonds one at a time, and on his burglary of habitation charge, his bond is set at $100,000, and we're asking the court to consider an amount of $50,000. If the bond was to be reduced to that amount, is that an amount you think that over time perhaps the family could possibly raise the funds necessary to make that bond amount?
It's more feasible, yes.
Okay. Now, the next case is the murder case. That bond is currently set at $250,000. We're asking the court to consider a bond amount of $150,000. And obviously, all the bonds would be, add them together. So if you add that to the burglary of habitation bond, and then additionally, the third case is an aggravated assault bond of $120,000, which we're asking the bond to court to consider $60,000. So if you add those three amounts together, is that an amount that perhaps over time the family could, or with the family's help, George might be able to raise the funds necessary to at
Yes.
some point be bonded out?
Mhm.
Okay. That's all I have for the purposes of this hearing, Judge.
All right, so do you have cross-examination?
Yes, ma'am. Mr. Hernandez, good morning.
Good morning.
I think you mentioned earlier that it's your understanding that Mr. Morrow does not own any real property, right? A
Mhm.
house, a ranch, or anything like that.
No.
So, he used to live, before he was seeking custody, he used to live in an apartment complex, correct?
Yes.
Okay. Are you the, aunt that was the property manager of the apartment complex?
No.
But he does have an aunt that was the property manager?
No, that's the wrong title. I mean, she does work there, she's not an apartment manager though.
Okay, what's her position?
As far as I know, I wanna say maybe like leasing consultant or something to the effect of residents, but I'm not sure what.
Okay.
I never asked him.
Okay, does he also have a family member that owns a bond company?
No, I work there.
You work?
Mhm.
Okay, so you work for the bond company, what's your current position with the bond company?
I'm a bonding agent, I'm a licensed agent.
Okay. So, are you familiar with the facts of this case?
Yes, I am.
Okay, how did you learn about it?
George called and went
So Mr. Amaro was the one that told you about it?
after the fact, yes.
Okay, so we have to assume that he's telling you everything that happened about the
Okay.
case, right?
Okay.
Okay, so, would you agree with me that somebody who murders another person, the person who murdered is a danger to the community? Would you agree with me on that?
No,
You don't agree with me that a murder is a danger to the community?
there's different scenarios. I mean, what transpired, what led to that?
Okay. And a person that has access to multiple weapons, multiple firearms, you don't think that that person would be a danger to the community, despite the murder charge?
I think that you have to look at everything.
Okay. What about a flight risk? You don't think that, it's my, are you familiar with Mr. Amaro's criminal history?
Yes, I am.
Okay. Are you familiar with him trying to flee from the police before?
No, and no,
Okay.
never heard of that.
And in this particular situation, are you aware that he left the scene when this happened? The building?
Okay, yeah, I was gonna say the building, yes.
Okay. And just making sure, you don't believe somebody who's been charged with murder is a danger to the community?
I believe that everything needs to play a part, that
Okay.
everyone should be given the facts and make a determination.
Okay, so we need the details to find out whether somebody is a danger or not.
I believe so,
Okay.
yes.
Fair enough. No further questions.
Alright, anything else?
Nothing further, Judge.
Thank you, Mr. Romanos. So, I think you said you don't have any other witnesses,
I have no-
is that
I have no
correct?
further witnesses.
Are you resting on evidence?
I rest on evidence, Judge.
Alright, and state,
Judge, we'd like to admit State's Exhibit 1, which is the criminal history, State's Exhibit 2, which is the special conditions of release, State's Exhibit 3, which is the bonds from the Odyssey program, and State's Exhibit 4, which is the prosecution guide. They have been submitted to defense for review. Defense, any objection?
No objection, Judge. I had reviewed them prior to the hearing.
so, all three of these offenses arise out of the same incident, is
Yes,
that what
Judge.
we're saying?
That's
Okay.
correct, Judge. I have more State's Exhibits that I'd like to admit, but if you like, the clerk could review the prosecution guide.
Start with this batch, okay?
state moves to admit State Exhibit 5 through 10, which are the photographs of the defendant's father's apartment, the place where the firearm that was used in this murder was found in a shotgun, and then States Exhibit 11 through 17, which are photographs of his apartment unit in Building 7.
You're moving to admit then States Exhibits 5 through 17. Objections from the defense?
Not for the purposes of this hearing.
Admitted. Okay, thank you. So 5 through 10 are photos of the father's apartment, of the defendant's
Where
father's,
he was located, yes.
or home,
Yes.
right?
The apartment, yes.
And 11 through 17 are where the defendant, or where the defendant was living.
Yes.
Court has reviewed States Exhibits 5 through 17. You have additional
And
exhibits?
then finally, the state moves to admit States Exhibit 18, which is the surveillance video.
Oh, you're gonna give it to me on the computer. Any objections?
Not for the purposes of this
Oh,
hearing.
okay, it's admitted.
There's 5 different videos in the CD, so I'm gonna play video 1 for the record.
Is this from the apartment at the time of the shooting?